difficult for me to pronounce, so I let her know to introduce herself. It's a very professional visit from judicial area of Poland, so the floor is yours.
Okay, but I need my presentation and the language that I should speak to our...
I think the better is English one. We have foreign speakers, Stefan and Andrzej.
Okay.
Andrzej. There's a better word will be English, I think.
Okay.
Mali sme dilemu, či po poľsky alebo po anglicky, keď sa nám zdalo, že poľština je nám blízka a že by to mohlo byť pre vás priateľné, ale vzhľadom k tomu, že máme týchto anglických speakerov, tak zdá sa mi to korektné a rozumné, aby Monika v rámci tejto odbornej časti s nami komunikovala English a v rámci neformálnej časti potom Polish. My sme to zvládneme takto multijazyčne. A každopádne máte v svojich materiáloch aj preklad do slovenčiny prezentácie, ktorú má aj Monika pripravenú.
Ale tu jest druga, a tu jest jedna, no.
Máme zase pána Bauera.
Kým sa spustí technika, ešte dovolte, aby som teda malý príbeh s Monikou vám objasnila. S Monikou sa zoznámili v Krakove na konferencii, ktorá bola zameraná práve na alternatívne riešenie sporov, ale vo všeobecnom rámci nie len spotrebiteľských, ale ADR, kde teda za Slovensko a za časť advokátskej obce som bola zastúpená, len nejaké, že iní kolegovia v tom čase asi nemali možno informácie alebo vedomosť. Tá konferencia bola veľmi vydarená a Monika je okrem toho, že je sudkyňa, tak je aj viceprezidentkou také európskej organizácie sudcov, ktorí podporujú mediáciu. A vďaka Monike a kontaktom s ňou sme sa pripojili ako Slovensko k tejto medzinárodnej organizácii v pozícii teda najskôr člena a takého maličkého, pretože sme nemali svojich členov z rádov sudcov, mediátori, boli členmi tejto organizácie a niektorí pracovníci súdu, ale nie z pozície sudcov. Momentálne sme v pozícii pozorovateľa, pretože bol aj COVID a aj nemali sme teda sudcov, ktorí by sme vedeli ponúknuť tejto organizácie ako adekvátnych členov, ale vďaka tomuto projektu, ktorý sme rozbehli v spolupráci so Spoločnosťou ochrany spotrebiteľov a vedieme komunikáciu s regionálnymi súdmi v Košiciach a v Prešove, tak zistíme, že táto téma je pre súdy veľmi zaujímavá, že majú záujem súdy viac spolupracovať s mediátormi, teda samozrejme nie je to ešte nejak politicky dané z nejakej politiky verejnej, ale záujem tých sudcov je naozaj začína byť citeľný. Takže sudcovia, ktorí s nami sú v tomto projekte trošku nakontaktovaní, už sa potešili tomu, že Monika prišla a bude prezentovať aj v rámci svojej prezentácie GEM, organizáciu, ktorá týchto sudcov zabezpečuje a organizuje. Is it okay?
Yes, everything is okay.
The floor is yours.
Okay, so thank you, Renata, so much for invitation to this symposium on mediation. As Renata already told, we have met a few years ago at the Congress in Krakow, and since then, Renata is a representative of your country, Slovakia, in European Association of Judges for Mediation, and Slovakia is one of the few countries that do not have national section in this organization, and this is why I am here as the vice president of this organization. So I have the privilege since May, because in May we have election. I don't know whether I will be re-elected, but right now I'm the vice president of this amazing organization, and Slovakia does not have a national section. To set up a national section of the organization, you need 7 members. 2/3 of them need to be judges. I would say that you can't promote and develop mediation in any country without engaging judiciary in it. So first we have to raise awareness among judges, and then judges should promote and develop mediation and other ADR methods in the country. So you were speaking how to make ADR in consumer disputes or any other disputes more popular in the country. My experience is without judges, without courts, you can't do it.
That's true.
Okay, one more thing. I put some data about me on the slide. The one important thing that inspired me to what I am doing is that I am the Weinstein-Jones International Fellow. And if any of you mediators or judges would like to apply, you have 4 days because the deadline for application is on Friday, but really it changed your life. So if you know any mediator or judge who would like to apply for the scholarship, please look at the website of this American foundation. They are making amazing things. They are supporting countries. They did it for Poland. So we are, since some years, a little bit further because of this foundation. I will show you some slides. They supported us for the training for judges, and they accept application from individuals. So this is my recommendation for you to apply. If not this year, each year they have open selection procedure for this fellowship. So as a fellow of American Foundation, I would start with the words that once Judge Sandra Day O'Connor said. So she was the first woman in the Supreme Court of the United States of America, and she said that the courts of the country should not be the place where the resolution of disputes begins, but they should be the place where disputes end after considering alternative methods of resolution. So first, all ADR types, kinds, then court. Court should be at the end, but the paradox is that without courts and judges, you can't promote ADR. So actually, whether we should speak ADR or EDR. So today we used alternative dispute resolution, and as the Association of Judges, we use different letters. EDR means effective dispute resolution. So we consider all this alternative not as alternative, but as an effective methods of resolution, of dispute resolution. What is more, we consider access to justice not as access only to the court, but access to a low-cost and effective means by which we can resolve conflict. All kinds of ADR or EDR are a modern way of resolving disputes, and it is a part of justice. The right to ADR should be enjoyed by every citizen, just like the right to court. So this is the broader meaning of access to court, and access to ADR should be understood by access to justice. So first, some words about consumer cases in Poland, because this is the topic of the seminar, and then I would come back to JEM, to European Association, and the role of judges in promoting it. So of course, Poland was obliged to implement the directive. We did it in 2017, and we had new rules on out-of-court settlement of consumer disputes. They entered into the force, and they apply to the resolution of disputes between a consumer residing in the territory of an EU member and entrepreneur that has a registered office in Poland. Disputes are settled by ADR entities, and in Poland we have, as was said, public and non-public private ADR bodies, and we have also commercial inspection, and she has branches in all regions in Poland. So we do not have 6, we have much more. I even can't count how many of them, and they are specified for different types of disputes. So each entity operates according to certain internal rules, and in most cases they are conducted for free. And I checked that the highest fee is 50 Polish zloty, which means it's like 10 euro. So, but most of them, I would say 90% are free of charge. The proceedings that they offered are post-claim proceedings. Participation is voluntary. Both parties, of course, must agree. And as a rule, the procedure is initiated at the consumer request. Of course, it starts an application for the initiation of the proceeding. The applicant should enclose documents, and the ADR entity is obliged to communicate the outcome within 90 days. In, of course, some complicated cases, it might be extended. There is a strong emphasis on conducting proceedings in electronic forms, but the traditional form is still available for both parties. And one of the ADR body, it is Financial Ombudsman Office, and I found statistics that since January 2016, they received more than 18,000 applications, and they have been concluded on the merits with agreements of nearly 2 million Polish zloty, and almost 2,300 cases in which it was possible to avoid litigation. Yeah, so it is actually all what I would like to say about consumer cases. And what you said, what was said already, it's not a popular form in Poland. So it exists, of course, these ADR bodies. We do not have any common official statistics, and it is not promoted in Poland. So I was very happy that you invited me for this kind of seminar. In Poland, we focus more on ADR and mediation that starts or ends in the court, and mostly consumers are not aware of these ADR bodies. They go directly to the court. This is why I will speak a little bit more about mediation and other ADR that could be from the court. So if you have any question, I will just answer after the presentation. But to emphasize, it's not the popular way of resolving the disputes. We do not have any campaign, and even judges do not inform about this kind of dispute resolution. So we have, of course, private arbitration. Let's say a consumer, and consumer can go to private mediation, to arbitration, and mediation by referral from the court to external mediator. And the last method is the most popular for consumers in Poland. Some words about European Association of Judges for Mediation. So we have 25 member countries in the association, and this year we are celebrating 20th anniversary of the association that was created in 2003 in Paris. It is European Association, but it is governed by the French law. It is an association of general interest with the purpose of bringing together judges. So all judges from European countries are gathering twice a year to exchange views, exchange experience, and inspire themselves. Currently, we have more than 800 judges. Polish section exists since 2016, And we do not have any Slovak judges. So as I told you, Renata is the representative of your country. And please believe me that without engaging judges, I don't know whether we have any judge in the room. If not, if you want to make mediation in your country more popular, you have to go to court, tell about JEM, European Association of Judges for Mediation, bring judges to the association, and then they will help you with promoting mediation. So the campaign that is made by courts, the leaflets that you can find in courts, the letters that judges could send to parties informing, for instance, about your NGOs, about what you can offer. Judges do have authority, and people still believe courts and judges, and they will help you to change the attitude of people and awareness of people in your country. Let's look at, so I will help you. First, bring judges to JEM. So let's look at two models of mediation that we have in Europe. So mandatory basis, and this is called opt-out mediation model, and voluntary basis. So it is judicial referral to mediation, and a judge can refer a case to another judge. It is called judicial mediation, or to external mediator. The first option, opt-out mediation model, exists in Italy, Lithuania in family cases, Greece, Scotland, and also Turkey, Azerbaijan, and Serbia. They just started with some kind of mandatory models. I do not have time to explain. If you organize the conference about mandatory models in Europe, invite me. Right now I will skip this because we will focus on some other things. So the second option is voluntary mediation, which means a judge referred to mediation. The best, according to statistics, judges for referring cases to mediation quite often, or are the best in Europe, are judges from the Netherlands and Slovenia. I told you that in Europe we have some countries that judges can act as mediators. It is not the case of Poland, it is not the case of Slovakia, I guess, but I put names of the countries. They are some of them in which judges can mediate in the court. So usually in Germany, for instance, I just did some visit to German courts, and they are very rare, refer to external mediators. They refer to so-called Gute Richter. It means a judge who is a mediator. How was it in Poland, and how is it right now? So we started with mediation in 1991, so it was quite far, long away, and we started with collective labor law, then criminal procedure, juvenile offenders, administration, and finally it was 2005 when we introduced a mediation to civil, including commercial, family, and other private law matters. Mediation in Poland is only on voluntary basis. We do not have this judicial mediation, and we can refer only to external mediators. We do not have any register of mediators in Poland. It is a plan of the Ministry of Justice to have such a register of mediators, but what we do have, we have a list of mediators that are run by courts. So we have district courts, 46 in Poland, and each district court has own list of mediators. And judges are looking at the list of mediators and searching for the proper mediator to the case. We used to have 1% of cases that were referred to mediation by judges. So the regulation from 2005 was criticized, and we know that we have to revise our provisions because we thought that we didn't implement properly the directive from 2008. It was the directive that said that each country should have a balanced relationship between litigation and mediation. And if our country, we had only 1% of cases that were resolved in mediation, so we didn't implement the directive properly. So we looked into legislation of other countries. And in other European countries, it is said that to conciliate parties is a part of the mandate of the judge. Belgian Civil Procedure Code says that the mission of the judge is to conciliate. So when we have experience from other countries that mediation to external mediators or conciliation made by judges in the courtroom, it is what is expected from us. We changed mediation provisions, and it was January 2016, and we have new legislation in Civil Procedure Code, and we hoped that we increase the number of cases that are referred to mediation, and that we will raise awareness among people. So first we introduced the obligation of parties and lawyers to inform in a pleading, in a claim, whether they have already tried mediation. So they need to write justification whether they tried mediation, and if not, why not? Why they failed. So this is the mandatory in the first pleading in the claim, that they have to explain whether they tried mediation. We have many new obligations on judges that we can't judge the case. First, we have to reconciliate parties. So we have to think about the case, whether we can reconciliate and offer the agreement by a judge, or whether the case is complex, need more time, need expertise, and refer a case to mediation. We introduce information, which is informative, I would say, meeting. So judges are allowed to refer parties not to mediation, but to the meeting that is in the court about mediation. And it is a practice in courts in Poland that when we got the case, we organize the meeting informing about mediation. Sometimes we invite mediators to the courtroom. So a judge is sitting next, and mediator is sitting next to a judge, and the judge can say how the litigation could look like, and the mediator explains mediation. We do have campaigns in courts, many leaflets, many posters about mediation. And we have obligations by the legislative to inform about mediation and about agreement, that we have to convince people that agreement could be better than the verdict issued by a judge. I'm just looking because I'm running out of the time. So what is important for these changes? Yeah. So right now we feel that judges are fully responsible for persuading parties to participate in mediation, and we do have authority to do it effectively and to increase the number of mediation. In Polish courts, we have so-called green rooms. So each court has a room especially designed for mediation. It should be the round table. Green was selected because maybe this is the color that facilitates the atmosphere for agreement. Such rooms exist also in other European countries. I have a photo. I once had a study visit to Finnish court. They also have special mediation room in courts. So from this room can be used by judges or by external mediators. So they can come to the court and invite parties to such room. So what is important in development of mediation? So first, education of judges, lawyers, and also children, even in the kindergarten, in the primary schools. And we do have special trainings for judges. So if you don't start, the first target group should be judges, not society. You should start with raising awareness of judges. We do have special trainings designed only by judges. They are conducting, I will show you some pictures at the end, by European Association of Judges for Mediation, by this American foundation and the Polish one, and we try to raise awareness of judges. We do have the Polish section of GEM. We are very active and we are offering many events for judges. The second thing is evaluation. It means that you need to have evaluation from mediation, that you know what's going good and what's going wrong. You need statistics. I don't know whether you have national statistics. So we have every 4 months and at the end of the year official statistics regarding mediation, and we really compete with each other. I mean, I am from the region in Krakow. There are some judges from the region in the north of Poland, and we are competing with each other which court is better in referring to mediation, and it really helps. So you need to compete. In October there is a mediation week, so-called. So in courts we are organizing so many events regarding mediation. We are inviting people to the court. We are having conferences, and then we publish the list of all national events that took place during this mediation week. Then the cooperation and positive attitude of lawyers. So the problem to development of mediation are reluctant lawyers. You also need to organize special training for lawyers, and the lawyers should understand their role, that they should be a peacemaker, not a fighter in the court. So you should start with training judges, then training lawyers, because if they understand their role, that they come to court and they fight, it's not good. There are some countries that lawyers are obliged to inform about differences between litigation and mediation. That is the case in Ireland. So the client and the lawyer should undersign the document, and the client undersigned that he was informed properly about litigation process, the costs of litigation and mediation. And it is something that we have in Europe, that lawyers think that they should fight for the clients, and that is their role. I recommend you very much. This is that on YouTube we have TEDx, the very inspiring speeches. And one is done by American lawyer. It is called Lawyer as a Peacemaker. And it is I like the speech of that lawyer so much. And in the United States, they already know that they get more satisfaction even if they represent clients in the amicable way of resolving disputes, not in the fight at the court. And the last one is inspiration. So we have to be open-minded and travel to different countries, observe what they already have, and inspire ourselves. I mean, in your country and in Europe, and even going to the United States. So I informed you about the fellowship that is offered to European mediators and judges. And why judges should promote ADR? So as I told you, we are highly respected. Well, but the truth is that people treat judiciary as people with moral authority, they respect, and it is the place where the campaign should start. And even because it is my impression from today's symposium that even about ADR bodies, private and public, where the consumers could go. So in Poland, I think that many people are not aware of it, and this is the idea for me from this very interesting conference, that in court we should also inform about this ADR bodies and out-of-court possibilities of resolving disputes. Yeah, so the role of a judge should not be just to determine a winner, rather to assist disputants in resolving their case. So it was 1976 when the Harvard professor Sander invented the concept of multi-door courthouse. And this is how we understand courts right now, that court has many doors, and only one door is litigation. The other doors are arbitration, mediation, negotiation. And the role of judges is to advise people the proper way to resolve dispute. So the role of judge is not to give the verdict. The judge should assist people, explain them all effective dispute resolution, not ADR, yeah. So about arbitration, mediation, and help people to select the proper way of dispute resolution. And there is also a survey made in Europe that judges get more satisfaction from their work when they help people to preserve good relationship, that they help them and not only decide who is the winner and who is the loser. The key to promoting judicial mediation is the awareness and training of judges. It is what I already told you, and I do have some pictures from the training that I am very proud of. It is the training that we organized already 2 times in Poland. The name of the training is Conciliation and Mediation Training with Mindfulness Elements. I don't know whether you practice mindfulness or whether is it popular in Slovakia. It is also something that came to us from the United States at the Judicial National College in the United States. They have a 1-week training, mindfulness for judges, and we combine elements of mindfulness with conciliation and mediation. And you see on the picture, so the first edition was only for Polish judges, and we do it in this way, that we selected 46 leaders in mediation, judges from different regions of Poland. And then we gathered all 46 judges and we inspired ourselves. We shared our experience. For the second edition, the pictures of which you can see, we organized for 46 Polish leaders and 16 Ukrainian judges. So we started to cooperate and inspire other countries. They are also the pictures from the training. We invite trainers from the United States, Belgium, Croatia, Bulgaria, judges who are who thinks that mediation and ADR is their mission. And our idea that I was talking about with one judge who was present during the conference, that we can organize such training for Polish and Slovakia judges for the third edition that will be in October 2024. Instead of Ukrainians, we can invite Slovakia judges because our legislation probably is similar. We can communicate easily and we can inspire Slovakian judges what we are doing in Poland. These are organizers of the training that I already told you, and that the third edition is October 2024. And here you have the email address to me. If you have any, well, I would say if you need any help, any assistance, or you have any judges that would like to join REM, please share my email address with them. I have also a profile and I put information about mediation events on LinkedIn. And I put here 2 addresses of websites. The first one is the website of the Polish section, and the second one is about REM Europe. So on REM Europe, this is the website of the whole organization. You can find all information about many, many events. So I have just come from the Athens, where we celebrated in Greece the 20th anniversary of the association. We have a very interesting conference about contribution of Greek to mediation. And on the website of the Polish section, national section, I recommend you, mediators and judges, to look at the templates of documents, because the Polish section, I don't know whether I can show it here, whether it is the Wi-Fi and I can get to the website or not. Maybe I will not, you will find it. So is it the website? At the end, I just want to show something from the internet. The Google or the Wi-Fi is here. If not, okay. No, but it's not the problem. So just have a look into the website of the Polish section. And we prepared a special document that judges can use in the court. So it is diagnosis of the case for judges, whether the case is suitable for mediation or not. And we are sending special letters to parties and to lawyers. And they are on the website. Because our languages are similar, you can read them quite easily, or you can translate them to Slovakia. So we, from the court, we send a special list to parties that I am as a judge, I read your case, and in my opinion, mediation would be better than litigation, and I indicate the advantages of mediation, and then a judge undersigns such a letter. So we send it to the party, inviting them to mediation. We have another letter to the lawyer, asking whether he already informed parties about mediation. We have a special questionnaire for the parties about mediation, and there are questions whether with the answer yes, no, I don't know, and at the end the party know whether mediation or litigation is better. We have also good practices between judges and mediators. So I really recommend also mediators to have a look at the website, already at the templates, documents that we created, and that might be useful in Slovakia. So you can print them, you can translate them, and go to the court, to the judges, and show maybe that would be the good idea. And in this letter, you can also add about ADR for consumers, And then people could be aware of this kind of dispute resolution. So we believe that if something comes from judges, from court, in oral or in written form, it makes people more aware. So start with judges, then lawyers, and then they will help you to make awareness of the society in Slovakia. So thank you so much for your attention. I know that it's 5 o'clock. We have to finish at 5. It was a great pleasure. And please share my email with your Slovak colleagues, especially judges, but not only, and the information about the association, the websites, and we will be very pleased to help you with creating national section in Slovakia and in any other aspects of development of mediation. So thank you so much.
Už sme skončili. Skončili sme, čo sa týka prezentácie. Thank you very much, Monica.
Thank you, Renata, for inviting me. Yeah.
Great presentation. I am very happy that